I know this morning, Robert was talking about ethics, some of the ethical considerations that you need to think about as you're preparing your experiments. But I want to focus on data ethics and governance here. The ethical implications and considerations for EEG data and also the legal issues that you need to consider. And this whole week, you've heard of so many neuroimaging modalities. We're focused on EEG, but there are other ones. MRI, what else? MRI, CT, X-ray. Sorry? Retina scan, yeah. PET, yes. MEG. What else? fMRI, right? So there are so many neuroimaging modalities. But for this workshop, we're focusing on EEG. And I don't want to get into what EEG is because you've heard of it. So many of you are already working with EEG, that's fine. Do you think, one thing I want to ask you, for those who have worked with EEG, you're working with EEG, right? Or maybe you've heard of EEG this week. Do you think there are ethical issues involved in the use of EEG? By show of hands, do you think, how many people think that there are ethical issues involved in the use of EEG? Those who are not raising their hands, that means you feel that there are no ethical issues, right? Right? Is that the case? You think that there are no ethical issues? Sorry? In terms of diagnostics, there are no ethical issues. Okay. So this is very useful. So what are the ethical issues to consider in neuroimaging data collection and sharing? And I know you were talking about informed consent earlier today. That is very important. But informed consent can only be informed consent if there are 3 elements involved in it, including clinical EEG, right? Informed consent issues are ethical issues, right? And you have to think about the 3 things that make up informed consent. Sufficient information provided to the patient. There has to be sufficient information that you provide to your patient. You have to make sure that they comprehend, they understand the information you're giving to them. And secondly, there has to be voluntary participation. You don't have to coerce them into participation. These are the 3 elements that make up informed consent. If one is missing, it's not informed consent. Do you agree? Sometimes, there's a reason why most companies, most tech companies, give you their terms and conditions in small print, right? Most often we don't read it, but you're supposed to read it. They expect you to read it. If you click yes, that you consent, that shows that it demonstrates that you have read through all the small prints. But how many people actually read that? How many people? You do. That's good. That's actually very good. I think maybe only 1% of the world population actually reads the small prints for informed consent for big tech companies. But we don't have to follow that practice. In research, you have to provide sufficient information that is comprehensible. Don't write big grammar for Mama and Kechi in the village, right? They would never understand that. And that is why, for us, most often it is relevant for us to translate some of the information that you're passing on to them in the local languages. If your participants don't speak English, meet them at the language that they understand. It's very important. Very, very important, especially for us in Africa where we have diverse languages. Maybe if you're working in a hospital in Lagos, you're meeting people speaking like 30 languages, right? 30 different people speaking 30 different languages. It's often difficult to translate informed consent documents into these different languages, but it's important to make sure that you're providing sufficient information in the language that they understand. And there is some voluntariness to the participation. If you go to the village and meet people who are not eating 3 square meals a day, and you give them 100,000 naira for participation, do you think that is just incentive or coercion? Coercion. Exactly. Is it a small mic?
No, it's the large mic. The battery is running out.
Okay, okay.
Where did the other microphone go?
Okay. So, and informed consent is at the core of the ethical issue of autonomy, the respect for autonomy. Because your participants or your patients, they have the right to make informed decisions about their involvement in the research. But I'll come back to informed consent in terms of data. This is for the research protocol. For the research protocol, there has to be informed consent, right? But I'll also talk about informed consent for the use of data. So, for some people who are not, maybe they're not familiar with the process of informed consent, sometimes I hear people in research environment that they don't know what to do in terms of informed consent because maybe they've just finished a graduate program. There is always an ethics board in your institution. It might be Institutional Review Board, IRB, it might be Ethics Review Board, however your institution actually, but in Nigeria, in so many other African countries, there are review boards in all institutions, including hospitals and diagnostic centers. So you have to prepare an information sheet about your experiment. You have to provide all the aims and objectives that you can think about in this document. The language has to be easily accessible, as I said earlier. The risks and benefits don't often run to write, there are no risks involved. Think about it. Have a reflection before you say there are no risks involved. Because it's very easy for us as researchers to say there are no risks involved because you don't want to go through the process of ethics review, right? You have to make sure that you put all this information in it. And most importantly for you as researchers, how would the data be managed? The data management processes. We often forget that. You have to put it in the information sheet. And then you have to put in your application. However process that is set up in your institution, you have to put in the application process for approval. And after you get approval from your institution, now you go to your patient. You don't have to talk to your patient. Actually, in the UK, you don't go to the patient unless you get your approval. I don't know how it is in Nigeria and other countries of Africa, but you don't talk to your patients or your participants unless you get the ethics approval. So once you get the ethics approval, now that's when you go to your patients, your participants, or maybe their carers, because if you are going to talk to people with degenerative diseases, they might not have the capacity to actually be part of it. And then you talk to their carers or their guardians, right? Or anybody that has the power of attorney on them. That is only when you talk to them and get their signatures. Very important to get signatures, whether digitally or in person. You need to get these signatures because when You write up your beautiful paper, and the journal asks you, where is the informed consent? Maybe one reviewer or the journal comes up to say, where is the ethics approval document? Where is the informed consent? You can actually easily pull it out. If you can't pull it out, that will be a problem. There will be a problem. So you need to get your signatures. Oral approval, in some cases, might work, especially for patients in emergency, but you need to get the signatures. Very important. So there is also the issue of privacy and confidentiality, right? Who knows what that is? What that animal is? Privacy and confidentiality. What does it mean to you? Yes?
It's my responsibility not to share data without following the standard laws.
Not to share data without following the standard laws. Yeah, that's close. That's close. Confidentiality is your responsibility to keep the privacy of your patient or your participants safe. Whatever they tell you through the experiment, through the research process, it is your responsibility not to share it arbitrarily. And the privacy is a wider concept that includes confidentiality, but also includes data protection. The protection of the data of your patient, right? And here we are talking about names, we're talking about age, occupation, address, brain structure, and functions, right? If I know the occupation of your patient and maybe the age of your patient, do you think I can identify who your patient is? Do you think, who thinks I can identify your patient from age and occupation? Yes, yes, yes. That's enough. That is enough to identify who your patient is or who your participant is. Two elements of metadata can actually help to re-identify your patient, especially if they are direct identifiers. And these are direct identifiers. So you have to keep them safe as a researcher, right? Oftentimes, are these included in your data? What are these called? Who can tell me what these are called in the scheme of things in terms of data sets? Sorry? It's biodata, yes. But also, it can be called metadata, right? Data of data, right? If you do your recordings, just the brain waves, that's the data set, right? But included in them, and the names, age, location, and all that, that's data of the data that you have, right? So that it can also be called metadata. So that is at the heart of privacy. All these information is at the heart of privacy. As a researcher, you must take measures to safeguard the participant's identity and sensitive information. It's your responsibility. So, one of the ways of doing it is to anonymize the data. Who has heard about data anonymization before? What does it mean? Yeah? Yeah?
Taking out direct identifiers of the data.
Thank you. That is only half of the definition of anonymization. There is direct identifiers and there are indirect identifiers, right? Anonymization means that you take out both the direct and indirect identifiers, and in such a way that they cannot be reversed. There is the element of irreversibility in anonymization, that you believe that it cannot be reversed. That is anonymization. You have to take both the direct and indirect identifiers. I'll give you an example. you go and get an MRI, right? And there is your name, your age, your address, and everything. And you remove all that. But the raw MRI, do you think it still has some identifiers? Is that direct or indirect identifier? Indirect identifier. So that is, it's not anonymized. If you remove all that metadata, it's still not anonymized, right? So you have to remove both the direct and indirect identifiers for it to be anonymized. But do you feel that, I know we're not dealing with MRI. Do you feel that with MRI, you can anonymize the data, remove both the direct and indirect identifiers? Who feels that we can do that? And it's still useful for research? Yeah?
I think we can do this, and it will still be useful if we assign different variables to the data.
If we assign different variables to the data. So by removing the direct identifiers, that's easy, and the names. The indirect identifiers will be the brain prints, right? If you remove the brain prints from the image, do you feel it's still useful for research? It's not. So that means it's practically impossible to anonymize MRI for research, right? So when we are talking about protection of privacy in that ecosystem, it is very difficult for us to do that. So the second best thing is always to de-identify the data or pseudonymize the data, right? Pseudonymize the data by doing what you were talking about, giving them other variables, right, that are not direct identifiers, right? So that is, you remove the direct identifiers and assign codes or whatever you want to assign to the data sets. That's fine. But for MRI images, then you have to deface the image, right? So it's not raw image. But that's not what we're dealing with today. So, who feels that, I know for the past 2 days you've been talking about brainwaves, right? Who feels that the brainwaves that are captured by EEG can be classified as brain prints? Thank you. Brain prints. So you have your fingerprints, right? And that's unique to you. By brain prints, I mean, there's an image that can be captured by the EEG or MRI or any other neuroimaging device that is very unique to you. The brain prints in your brain that is very unique to you, that you share with nobody else. So brain waves that are captured by EEG have been identified as brain prints. So if there are brain prints, do you feel that if you share your EEG without anonymizing it, by removing the direct and indirect identifiers, do you feel it to still be useful for research? It's the same logic with MRI, right? It's the same logic with MRI. So that means even if you remove the names, addresses, locations of all the patients, if the brain waves can be classified or can capture brain prints, it's still personal data. It's still re-identifiable, right? If somebody has a database that has other maybe related recordings or your recording somewhere else, it's very easy for the person to re-identify you. And there are studies that have actually shown this. So in terms of, there are so many studies. In terms of re-identifiability of EEG data, this is an example of how it is so easy to re-identify anything, right? In this study, they actually used, who knows what this is? This image here. Have you ever seen that before? In Netflix or in any website where you're asked to rate your preferences, right? So with people's anonymous rating of their preferences in Netflix and in IMDb, it was easy to identify people just through their preferences. So it's easy to link up data sets to re-identify individuals. And that is why there's a study that came out a few years ago that showed maybe it's practically impossible to say that anything is anonymous these days. Practically impossible, because we all have how many people has Facebook account here? All of us. How many people has Twitter account? LinkedIn? So we all have our data sets out there, right? So it's very easy. There's no way we can say maybe our online activities are anonymous, right? Even when these big tech companies offer you encryption, I don't think it's still encrypted, right? Okay. So it's very easy to link up data sets, because I hear some people thinking that, yes, I can share these data sets. That's fine. Yes, that's fine. But the possibility of re-identifiability is also there. So we have to be careful in terms of how we share the data. So, and this is another example of how anonymous browsing data can be easily exposed. So it is easy to also identify your participants or your patients through data. But then what do? There are legal status that we need to think about. This is a question for Nigerians. Who has heard about the Nigerian Data Protection Act here? Nigerians. Nigerian Data Protection Act. How many people? You've heard about it? So the fact that not all Nigerians raise their hands means that not everybody has heard about it, right? Maybe if I ask how many people has heard about the GDPR? Everybody? Almost everybody, right? But there's one in Nigeria, similar to the GDPR. But I know most researchers in Nigeria, you've never even read it or understand how it impacts your research. And that's the same way in the whole of Africa, actually. If you ask, okay, the Kenyans are not here. If you ask the Kenyans, there's also a Data Protection Act in Ghana. Have you heard about it? You know how it impacts your research? Good. So most of the provisions for the GDPR were actually extrapolated to be put in our data protection laws in Africa. Just trust Africans, right? The GDPR, okay, I don't blame Africans, I blame Europe, actually. Because there's a structured agenda in Europe to actually go first in all regulations and then show the world how it is done. It's called the Brussels effect, right? And it happened with the GDPR. The GDPR was the first comprehensive data protection law in the world, and almost every country actually copied the GDPR provisions. Anytime I read a data protection law in Africa, it's similar to the GDPR. So similar to the GDPR. But something that is different in that is that most African countries are following the data localization policy that was started by the GDPR. Almost every country in Africa wants their data to be located in their countries. They don't want data to leave, including the Data Protection Act, the Nigerian Data Protection Act. Actually, let me tell you guys now, if we follow the letter of the DPA in Nigeria, you should not even share health data unless you get express permission from the Data Protection Authority in Nigeria. Express and written permission from them, which is a very difficult process. A very, very difficult process. But the implementation of this law is still up in the air anyway. So I'm going to talk about some of the provisions of GDPR, which is very similar to what we have in Africa. It's for you to understand what processing means. Processing data, research data. Data processing is any operation or set of operations that you perform on a personal data. Personal data. And what is personal data? Any information relating to an identified or identifiable person. And who is identifiable person? Anyone that can identify, identifiable, yes, but a person is not, it doesn't apply to dead people, right? If you follow the provisions of the GDPR or any data protection law, right, once you're dead, it doesn't apply to you. But so many countries in Europe are actually using national derogations to change that now. I think in Denmark, I think they have started, I think it has been passed or something. They've started thinking about how to include post-mortem data in the provisions of the GDPR. So it doesn't apply to dead people, it applies to living persons. And identifiable means that if anyone can identify a natural person, using all means reasonably likely to be used. That is a very important clause there. All means reasonably likely to be used. And I'll come back to that. So, examples of personal data will be your names, telephone numbers. These are direct identifiers. We were talking about direct identifiers earlier. If I have your phone number, I know who you are, right? If I have your name, I know who you are. If I have your ID number, I know who you are. If I go to your workplace and get your human resource information, I know exactly who you are. Your IP addresses, who thinks the IP addresses can identify them? Who knows what is IP address? Who doesn't know? Who doesn't know what is IP address? Okay, we all know. Okay, you don't know. The internet protocol, right? As you browse, right? There is a protocol that your browser and your computer actually has. It's very identifiable. If somebody has that at your IP address, they know exactly if they know the owner of the computer, yeah, sure. Your location, yes. So, and then there's another category of personal data, which is called special category data. Personal data revealing your racial or ethnic origin, that's very special, especially in the context of Europe, but also in the context of Nigeria and Africa, where we have so many ethnic groups and ethnic tensions, right? It's also special data. Your political opinion, your religious or philosophical beliefs, but the most important there is data concerning health. If you're collecting EEG, if you're collecting MRI, that can be classified as data concerning health, right? So that means if you're collecting EEG, you're collecting special category data. And it's special category data because it requires special protections and safeguards. It requires special protections and safeguards. It's not the same as general personal data. It requires special protections. So, the data protection laws do not apply to anonymized data. It does not apply to post-mortem data or animal data. Most of you are maybe collecting animal data. It doesn't apply to it. Post-mortem data, it doesn't apply to it. Anonymized data, when you have removed the direct and indirect identifier, it doesn't apply to it. But if you remove the direct identifiers alone, and the indirect identifiers are there, it still applies to it because it's still considered as personal data. Is that clear? So, what do? The first thing you do as researchers is to understand the lawful basis for processing the data. Almost all data protection regulations, including the DPA and the one in Ghana, the one in Kenya, and the one in Uganda, they all have what is called lawful basis for processing data. You have to identify the basis that you're processing the data that is lawful, right? The second thing you do is to develop technical and organizational measures to protect the data. This includes conducting a DPIA, that's the Data Protection Impact Assessment, anonymizing the data or pseudonymizing it, and then encryption. Encryption is, I'm going to talk about that more. Encryption is very relevant here because if you do, it solves a lot of problems. Even if there's a breach, a data breach, the DPA or your Data Protection Authority will take it lightly on you because they will believe that you have done everything you're supposed to do. And then organizational safeguards will include data use agreements, data transfer agreements, data processing agreements, or joint data controllership agreement. But I'm going to talk about that later. So some of the lawful bases, especially this is the same in the DPA in Nigeria, might be consent. One is consent as a lawful basis for processing. That means the patient gave you their consent to use the data. Another one is contract. If you're in a contract with an individual, right, for the purposes of that contract, you collect personal data and use it, that can be a lawful basis for processing. And then legal obligation to comply with the law. Maybe when you deal with law enforcement officers, that might be their lawful basis for collecting your personal data. Vital interest, public task. Who thinks that the research you do in your universities, in your institutions, are part of public task? Who believes that? Nobody. A few people, right? Sorry? The research you're doing, the biomedical, your neuroscience research that you're doing, do you feel is part of public task? It is. It is part of public task. It is public task. So when you carry out research, who carries out research on herself or on himself? Just for your own purposes. Is there anybody that does that? Yeah, so you can, but 99% of what we do is for public task. So that's necessary to perform a task in the public interest or an official function, or it is necessary in law and legitimate interest. So in Europe, data protection authorities encourage researchers not to use consent as a lawful basis for processing. Consent is always the wrong basis for processing. Because and I'm going to tell you the reason why. You're encouraged as researchers to use public task as the lawful basis for processing. Public task. Because that's a very safe option. Because consent is difficult to get. Both broad consent and specific consent or dynamic consent. It's very difficult and very complex minefield. I'm going to talk about it. If you are processing general personal data, you're required to identify one lawful basis for processing in this article. Among the 6 of them, you have to identify one to process general personal data. It is the same for you as Nigerians under the DPA. And if you're processing special category data, you're expected to identify one among the earlier 6, the previous 6, And then another one in Article 9. Which one do you think fits into research? If you want to identify one in Article 9. Look at them, 9 of them. Sorry? Oh, so the last one, yes. For archiving purposes in public interest and scientific or historic research purposes. I don't know how many times I've had this. I actually had this last month. I was in Germany, and this was also a group of researchers. And somebody stood up and said, we have so much data in our institution, but our DPO, that's the data protection officer, doesn't want us to share because we don't have consent as a lawful basis from the participants to use the data or to share the data. So they can't even share it. So the consent I was talking about earlier was for the research protocol, right? Now I'm talking about consent as a lawful basis, which is completely different. So in your informed consent process, you have to add there, if you want to use consent as a lawful basis, you have to add in the informed consent process. You have to add it there that you're going to use this data for this, 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 and this, and you have to identify all the relevant uses, both now and in the future, which is often difficult, right? But if you want to use consent as a lawful basis, you have to identify that in your informed consent protocol. And then the patient gives you the consent, not just to participate in the research, but also to use the data for further research. Yep.
Even if the person's direct and indirect identifiers are removed.
If you remove the indirect and direct identifiers, the law doesn't apply to the data again. But you have to make sure that you have removed that. It doesn't, okay, your data is not anonymized because you said so. Your data is anonymized because there's what we call re-identifiability test. How much time will it take to re-identify the individual? How much money will it cost to re-identify? If it costs like maybe 5 million euros to re-identify one individual, right? If it takes like 2 years to re-identify one, and then is there the availability of technology to re-identify the individual? A few years ago, I'll give you an example. A few years ago, if you're using MRI data and you deface it, but you can talk to them about the tools to deface data sets. If you deface the data, it was sufficient for you to say it's anonymized, right? It was sufficient for you to say it's anonymized because you feel you've removed the indirect and direct identifiers. But so many years later, a few years ago, with the emergence of AI, right, the door was opened up again. Now you can reconstruct the facial structure of the individual from a defaced image with machine learning tools and all that. That means there is now availability of technology. What was classified as anonymized a few years ago is now pseudonymized, right? So if you consider the test of re-identifiability and it takes longer time, it will cost a lot, and there's no availability of technology, then it's anonymized, right? If it is anonymized, the law doesn't apply. If it is not, it applies, right? And then I don't want to go. The reason why I was talking about informed consent not being the right lawful basis for processing earlier is that your data subjects, your participants, your patients, they have rights, right? They have rights to be informed. They have right to access the data. They have right to rectification. They have right to erasure. Do you know what that means? Do you know the implication of that? Right to erasure. They have the right to come to you to say, every data you have of me, delete. Yes. They have the right to restrict the processing. Or you have been processing the data and they tell you, oh no, I don't want you to process my data again for this research. They have the right to that. And also they have the right to data portability, maybe taking their data from your system to another system, right? And also they have the right to object. Yeah? Okay. So I'll come back to your question. The reason why it is not the best, informed consent is not the best lawful basis is that if you use consent, the data subject will always have the right to erasure and will always have the right to portability. If you have anonymized the data, if you have maybe published the data and you don't know where the data is now, you have shared it, and maybe 3 people have downloaded the data and they're using it and they're sharing it with their friends, you don't know where the data is again, right? So it's difficult to fulfill that right of erasure if you use consent, right? Very difficult to fulfill that right to the data subject. But if you use a public task, are you seeing the public task there? If you use public task as your lawful basis, the data subject can't come to you to say, I have the right to erasure. They lose that right. Right? And they lose the right to portability. And which is important for us as researchers. We don't want, you have 100 participants and 10 of them come to you to delete their data. It changes the dynamics of everything. You don't want that. So data protection authorities encourage researchers not to use consent as the lawful basis. It's the wrong lawful basis to use in research, actually. So when you're considering the Nigerian Data Protection Act, you have to think about this also. Yeah?
The research participants are potentially dangerous to the general public.
So you're thinking that you need to report them or what? I didn't get the question.
For instance,
Yeah?
we conduct, let's say, males with sexually transmitted infections on a group of males in a particular region. Then at the end of the day, we have certain findings, and then we realized that behavior of this particular males are predominant in certain regions. And we want to use the research finding to advise the affected regions. So which will mean that the research is now pointing towards general attitudes of general public and then health-related implications. And then states might say, okay, I have interest in your findings. We have to use your findings to protect the public. Then the participants right to say, okay, we don't want our information out there anymore. What will be the conflict?
Okay, it depends on what information you're talking about. If you're talking about the statistics from your research, I don't think it can be used to re-identify the individual, right? If you're talking about anonymous statistics, that means the law doesn't even apply to it. It's anonymous statistics, right? So you can simply pass that on. But giving the government access to the personal information of your participants, depends on what government. If it's in Russia, maybe. If your life is at stake, I wouldn't advise you in that situation. But generally, I think the principle in ethics is that you have to protect the confidentiality and privacy of your data subjects. Yep.
I just wanted to talk about what happened this issue of confidentiality when we had that Ebola case.
Mm-hmm.
So that kind of situation is not something that you talking about confidentiality because it's a very huge, health risk for the entire country. So the man had to be identified. The subjects had to be identified and tracked down. So I'm just wondering, do you have provisions for that?
So I think in every country there are exceptions to these issues because that is an emergency, a case of emergency, and in the case of emergency, it's taken as if maybe in a situation of war, right? So even in the UK, where I live, even in Europe, some laws are suspended, some ethical principles are suspended for the benefit of the society. It all happened to all of us during COVID, right? Yeah, you also mentioned Ebola. It all happened to us during the COVID, right? Even some people that didn't want to do a few things, they were forced to do it, right? Under normal circumstances, you can sue the government for that, for actually breaching your rights. But you can't. It's to save the public. Yeah? Yeah. So,
the leadership, you tend to look at the US, but we tend to look at the United States of America. None of this, and I'm wondering whether the dynamic is not changing because of the government that we have here. We know things are changing rapidly. And sometimes we look at the US as the leader in most of these critical stuff, but in the last 3 or 4 months, things that are coming out are not pleasant.
maybe I wouldn't want to comment about the US. So, yeah. So, I wouldn't want to comment about the US. But I think even in the US, in cases of emergency, some laws will have exceptions. I don't know whether you know about the LA riots that have been on for the past few days, right? There are military people on the streets of the US now. Under normal circumstances, that should never happen. But they're doing it because they feel that there's an emergency. I don't know if there is anyway.
So I'm asking, can it be said that when a global epidemic is called, is that one of the strategies to also set aside the ethics? For instance, in the case of during the COVID,
Yeah.
the survivors of COVID were already, exposed. For instance, the index case in Nigeria was already announced all over the place. So I think along the line, when WHO called, it's an epidemic. So if the patient at the time or the survivor eventually decides to sue or say, I'm entitled to, does that call protect the government or those who published?
Yes. That's a simple answer. But I don't know whether you guys have forgotten, during COVID times, I don't know if it happened in Nigeria, but in the UK, there was what we call contact tracing, right? You have COVID, you've been identified, all your contacts will be identified, and information passed on to them, right? Under normal circumstances, no person should do that for any disease. But we're doing it during COVID to save the public. So sometimes, in cases of emergency, depending on how the government defines it, it doesn't need to be a global epidemic. Depending on how the government defines it in the particular country, then you have to go back with that.
So in the Data Protection Act, there's a clause
So in cases of that, the GDPR was a big issue during COVID in Europe. People were thinking about the GDPR, but it was very obvious that some provisions of the GDPR were actually paused during COVID. If that happens any other time apart from that epidemic, people will sue. But you can't get anything even if you sue because it's an emergency, right? And then organizational safeguards. If you have identified your lawful basis, you've developed your technical and organizational measures with pseudonymization, with encryption, and then you have to set up some of these agreements, data use agreements, data transfer agreements, data processing. Who has seen one before?
If you publish with journals, you have to sign
Data transfer agreements. In some cases, when you're, depending on whether you are transferring the raw data, or maybe you're putting the raw data somewhere as a requirement for the journal, right? You have to sign that agreement with that repository for open source and things like that, yeah. Sure. So, but if you're sharing your data, you have to protect yourself and protect your patient with data use agreements, data transfer agreements, or data processing agreements. And these are different. Let's say I have EEG data, and you want to use my EEG data, right? And I've set up I've identified my own lawful basis for processing. I've set up maybe encryption protocol, or maybe I've anonymized the data, or pseudonymized the data, and I give it to you. What will be in the data use agreement is that now you have the liabilities to use this data as a data controller. So you have to identify your own lawful basis for processing the data. You have to set up your own safeguards for the data. And that will be, if there's any breach while you're processing the data, you will bear the responsibilities or the liabilities. Right? Or data transfer agreements. If you are transferring this data across borders, sure, you set up data transfer agreements. And controllership. Controllership means that somebody that controls the purposes and means of the processing. If you control the purposes and means of the processing, you're a controller of the data. That word is special because ownership is not used. Why do you think ownership is not used here, but controller? Who knows why? Can you own somebody's personal data? If I had asked you earlier, that if you collect EEG from patients and you have it in your lab, who owns the data? What would you say? Sorry? The consultant. Who owns the data?
The patient.
The patient. That's right. You do not own the data. You cannot own somebody's personal data. Not in Nigeria. The consultant can be the steward or the controller of the data, but not the owner of the data. He cannot own my name or my brain prints, can you? But you can control it. It can be in under your control, but not own it. But yes, I agree with you that in most cases, they feel that they own it. Some PIs or supervisors also believe that they own the data, but you don't. You don't, exactly. You control the data, but you don't own it. You can control the data. So if you are, maybe there can be joint controllership, right? I am in my institution and you're in your institution, and we collect this data together. Jointly, we control the purposes and means of the processing. That's controllership, right? But even if that data is in my possession and there's a breach, who do you think is liable? Both of us. Not just me. Both of us. So you can also have a joint controllership agreement. But whether you have the agreement or not, if you control the purposes and means of the processing, you are joint controllers. So, another one is encryption. I've talked about anonymization and pseudonymization. Encryption, whether at rest or on transit. If you set up encryption for your data, you're adding an additional privacy layer to it. Sometimes people hate encryption, encrypted data, right? Have you ever received data set before and you expected to put a code before you access it? That's encryption. It's encrypted, right? Lots of people hate it. But it's an additional privacy measure that can actually protect you as a controller of the data. Okay, so I don't want to get to this. That was what I wanted to talk about earlier. Ownership of data. It's important for you to understand the idea of ownership of data, right? How many of you are collecting data sets and you're saving it on the cloud? One person? Just one person? Sorry? You're protecting the data. So you're holding it in your lab. So you're protecting it. So it is important for us to always have control over the data. As I said earlier, you can't own the data, but you need to control the purposes and means of the processing. Don't relinquish that responsibility, especially for us Africans. Especially for us Africans. Who has heard of data colonization before? We've never heard of it. Thank you. So, yep. I'm coming to that. Yeah, I'm going to come to that. So, during COVID, I don't know whether you guys know this. During COVID, Africa did not produce vaccines, right? We did not have sufficient data about what was happening with COVID, right? Do you feel that we didn't have the data? Or that maybe the data sets were not in our possession? One person? Yes? Ebere? It wasn't?
We had the data, but it wasn't fair. It wasn't open or accessible.
So what she's saying is that we had the data, but it wasn't findable, accessible, interoperable, and reusable.
Data processed properly.
Yeah, that was one of the issues, yes. Maybe most of the data we have were still in our labs. They were not fair. Nobody could access it, yes. But majority of the data we had were not in our possession, right? Because most of the research where data collection is involved in Africa, who funds it? Right? Mm-hmm. Right? Who funds it? Foreign funders, right? They fund it. Most often, there is the condition of storing the data somewhere else, right? Most often, we willingly store the data somewhere else, right? So when COVID hit, when we were supposed to make use of our own data for our own benefit, we didn't even have access to it, right? Most often, I think he's not here. I was having a conversation with somebody who is also part of these sessions. And they are, okay, I don't think he will mind. So they had an EEG device donated by an NGO. Lots of, I think 2 or 3 EEG devices, right? By an NGO. But the condition was that they save the data on a storage created by the NGO through an app developed by the NGO. Right? What they do with the data, the hospital here doesn't even know. The only thing they benefit from is that they have people that can read, interpret the images, right, and give them results, which is good, which is awesome, can save lives, right? But if you Google that NGO that building models, AI models, what data set do you think is contributing to the model? Exactly. So we need to always have control of the data sets that we collect for the benefit of people in Africa, especially researchers in Africa. Make it available for others to use, that's absolutely fine. FAIR is one of the things that we are focusing on in African Brain Data Network, to make sure that we encourage findable, accessible, interpretable, and reusable data in Africa. A few years ago, we wrote a paper with a Beret on challenges of FAIR brain data in Africa, FAIR brain data in Africa. And one of the things that we discovered was that we went through most of the available open repositories, right? The open ones, to see if we can find any available African data sets. We couldn't see any. We couldn't see any. That is a very dangerous precedent, because these data sets that are made open are going to lead to therapies, the development of innovation that might not be generalizable to the African population. So it is our responsibility to generate those data sets that are going to lead to the therapies that will be effective for our own population. It is your responsibilities, our responsibilities, to do that. But as you do that, you have to understand the enormous responsibility you have to always control the purposes and means of the processing of the data. Very important. Very, very important. Any questions? Yep.
Thank you for this lecture. So you made mention of an IP address. So what about people that use VPN? Because I heard this VPN like you can't find me and stuff like that. So does VPN affect it?
Okay. VPN hides your identity, right? Yes. But it's not foolproof. It hides your identity, that's true. But I don't think all VPNs also are foolproof. It's the same thing as blockchain, right? They confuse you and tell you that blockchains are very safe, right? But there's somebody at the back end, isn't it? Right? There's still somebody at the back end. I think tomorrow, the guys that booked here, they're going to talk about blockchain. I met them earlier. And I was asking them the same question, right? The field is safe, that's fine. You can't crack it. Okay. I said, that's good. But there's still somebody at the back end. Blockchain is not that private.
I'm also wondering about this control of data and our practices and universities in Nigeria, where you encourage people to publish outside the shores of the country. Even when this information was coming about COVID, everybody was rushing whatever they had, and they were sending it to foreign journals. And eventually, we don't even have access to them here in Nigeria.
That's one layer of the problem. But I'm not just talking about the publication of the paper, right, which will be the results of your experiments, right? I'm also talking about the data sets that led to the publication. Because that is what some other person can use to do something else, right? Most often, I don't think we're there yet, where we actually share the raw data that we collect. Because oftentimes, I didn't want to talk about this earlier, we don't have motivation to. Because we feel, I've spent a lot of time, energy, how can I give it to you for free? right? Okay, it depends on what data set. There are so many open repositories that you can share data sets. Open repositories, even surveys that you can share your raw data for surveys. Zenodo, Figshare, there are so many other ones. I'm not just talking about EEG data that you can share in Open Neuro or eBrains or BrainLife or any other repository. Sorry.
What would you advise in clinical settings where there are a lot of personal identifiers and the EEG recordings are used by resident doctors? There's no consent from the patients. Is it okay in that setting to share the data?
So if the doctors are also still using it for clinical purposes for the patient, that's fine. Sorry?
You acquire this data.
For the research,
You acquire this data now.
Yeah.
Now you for publication.
can you use it for publication? Okay, they are doing it. Oh.
Most likely they tend to extract those data, and then you see some residents and some consultants they come together to use that data to publish that ethical.
I think direct identifier.
Sorry. So, okay. Okay.
So, a typical scenario is one of my students, that wanted to know more about whatever she went for in the hospital for the ABDN and everything. So she went back to the hospital. Please, consultant, I want my own data. I want to see. They told her that once. Are you not okay now? Please go. We don't show you. That data is not your own. It belongs to us. It belongs to the hospital.
So that is wrong. That's wrong because they don't know. And I think they're operating from the point of ignorance. Hello? Hello? Abraham, let me answer the question. So, yes, that's wrong because as a patient, you own your data. Sure. But also, what I also know is that sometimes they collect money from you for administrative purposes to extract the data from their machines to give you. Sometimes they do that. But for the clinicians who are using the data without proper informed consent from the patients for research, that is ethically wrong, right? That is ethically wrong. If they did, what they can do is to set up an informed consent process for the patients, right? To include the use of the data for research, right?
Yeah, but you add another layer is that the patient actually paid for the testing.
So the patient paid to be scanned, and then you don't ask whether the patient wants you to use their data for research, but all of a sudden you use it. Okay, so what I can also add there is this. I was talking about informed consent as a lawful basis for processing earlier. If you can go through the ethics approval document, you can go through the institutional review board and talk to them that the lawful basis for processing this data will be public task and you want to use it for so and so, and they approve it, you have an ethics approval to use it. That is absolutely fine. Right? But you have to go through the ethics approval process. So that is retrospective data, right? So many hospitals are already familiar with this process, especially in Nigeria because we have spoken to them before. So they are already familiar with this process where you can go through the institutional review boards but you have to identify your lawful basis, not as consent, because people still make the mistake that it is consent. It is not consented to. You have to use public task. You. Yeah.
gave an example of MRI that has been defaced properly before being decoded or being
Re-identified.
reconstructed. So, is there any permanent solution? Because from what I know, DPR always play catch up with technology. It will always play catch up. And you don't want to go back and say, oh, the data you publish, you have to use another method to deface it now and you publish. Is there any permanent solution to that?
If there's a permanent solution to that, there will be happiness in the land of neuroscience community. So Robert and I are also part of a cost action project that is starting in October, I think so, that is specifically for that, to find a solution for that, right? I'm also part of a bridge project, which Ebere is also part of, and we're also thinking about that. There is no permanent solution. What people are doing at the moment is to develop a very strict access control mechanism for the data, right? If you want this data, that's fine. I want to know who you are. You create an account, you sign the DUA, and you use the data, and you are liable if there's any breach from there on, right? So there are processes of doing that now, but it's still not as free as the way researchers want it, right? They want something very agile, very easy for people to have access to data sets. And it also, not all institutions can set up such access mechanisms. So it's still difficult to access data sets if they are defaced. Yep. Sorry, I'm coming to you.
So on the issue of publishing data on the cloud, is it actually okay if it's like my private cloud? Because within my lab, what we do is we do have certain servers, certain NVIDIA RTX 30 series servers, and we have all of our data on those servers. Then we actually make use of like an AWS interface, so for a website for you to access it. So at any time, we can actually like shut down the servers and you cannot access. But is that safe, since we are still making use of AWS or external?
Okay, so from the point of view of the GDPR, some cloud systems are GDPR compliant. Some cloud systems are GDPR compliant from the GDPR perspective. This is something that has not been done in Nigeria or in any African country, actually. So they have these localization policies, but there are no HPCs. There are no storage systems locally to store the data sets. Even government data sets are actually stored on cloud. But yet, they have these localization policies to keep everything in local. So it's still a problem. Even when you want to store your data locally in Africa, there are no sufficient storage for the data sets in Africa, right? How many data centers are made available for people to use, actually? I don't think there's any university that has a HPC attached to the university, or maybe a data center attached to the university in Nigeria. You do? That's good. So why are you using AWS if you have a data center?
We only use AWS to have the server for the website, which you use to access our local server.
Oh, so there's a connection. Okay. Okay. No, I think from the point of view of Nigeria, it's still very difficult to store locally. And now you have this connection where somebody can also access through AWS. It's still, but find out if it is compliant in the eyes of the DPA. I can't advise you on that. Yeah.
Thank you. It's not that I'm trying to side the hospital or something like that. But actually, where I did my industrial training, after you have seen your consultant and everything, we in radiology, because I worked actually in radiology, we will tell you is that if you want to keep your film, because it's your decision. But the mistake I feel they make is they don't, when the patient says, yes, I want to keep my film in the hospital in case I come back to get the films, they don't issue them like something to sign that your film might be used for something. Because I've been in the hospital where a lecturer came actually and met with the HOD and everything. So my IT coordinator was like, you go to this place. we went into archives and got film records for this professor, and he went with it. But there was no, I did not see any consent from the patient. And funny enough, this patient, they paid for these films. So it's not outside the hospital, but they actually let the patient know that you can go with your film. You can also keep it. But the mistake they make is they don't issue the consent form while telling them you can keep it.
So there's plausible deniability there, isn't it? So, yes, I know that happens in Nigeria a lot. That happens in Nigeria and in Africa a lot, right? I know, but the right thing to do is for the hospital or the diagnostic center to set up an ethics review board that can review those applications and approve or reject some. To understand what you want to do with the data, to understand your lawful basis and how you're going to manage the data before they give you approval. Yeah. Okay, so I don't want to get through the process of the murky waters of consent process in Nigeria, right? It's very murky, right? I don't want to get through that. And the payments that go through to get the approvals, that's not what I'm going to talk about. But I think it's about having a very structured process of assessing the applications and providing approvals when there is need for it. Okay, sorry.
Yeah, just to add to what you have said, and what she also said, he might not know while doing his IT, because I actually worked on retrospective study, right, in the radiology department, and I had to go through the process. My institution, first of all, had my medical reviewed, and when I got to the hospital, the different hospitals I worked with, I also met with them, they submitted, and they also, gave me the medical approval before I went into the archives to get it. It was the radiologist there, the radiographer that helped me to get all the details that I want to. So, but he might not know that I've gone through this process, but I did.
No, that's true. That's true. In some cases, yes, that's true.
Students and also be used for research. So it's one of the things that patients are told. They are told, like, the patient comes and you want to examine the patient, and they say they don't want people to be and students to be around, then you shouldn't come to the teaching hospital. Because for you to come, then you must agree to be used for such a purpose. So I think that's not
I know that there was an advert on Twitter where people were talking about if you're going to the direct and you're not comfortable with a male gynecologist treating you, it's okay for you to come to continue. So are you saying that because it's a teaching hospital or because it's a research center, we should now override patients' comfortability or consent?
That's what I'm telling you. If you don't want to be subjected to that, then there's no point coming to the center like that. Because you cannot determine.
So I want to respond to this. So there are a few things. This is where the African dynamics come in. There are a few things in terms of human rights, in terms of our rights, that can happen in Africa because of lack of infrastructure, because of lack of personnel, that will never happen maybe anywhere else, right? Because I know in hospitals here, sometimes, whether you like it or not, if it is a male doctor that is available, that's it, right? If it is a female doctor that is available, that's it, that's fine. But in so many other countries, those things will not be allowed to happen, right? Whether it's teaching hospital or not. So it depends on, for me, it's contextual, and also people have not tried it in court. If somebody takes it up and maybe get to the highest level of the courts in Nigeria or in the society and it stands, then that practice might stop. Because it's about human rights also, right? But I'm not saying that it should not happen. There might be extenuating circumstances that will make it to happen, right? But when we talk about ethics in general and not contextually, I think we need to consider also some other things. Yep. I think this will be the last question, sorry. And we can talk, we can surely talk during dinner.
Just a contribution.
Yeah, okay.
I was privileged to do my postdoc in Massachusetts General Hospital. I'm a basic scientist. And I wanted to watch a procedure when a neurologist was clapping a patient.
Okay.
And she asked the patient, do you mind Victor being here? Because she needed to know what is happening so that she can model this in the laboratory. Massachusetts General Hospital is one of the teaching hospitals for Harvard University. And they were consent.
Yes, but
Let me just tell you something, what we do here.
I thought it was the last contribution.
You know what we do in Nigeria?
Okay.
Sorry, it's not a question. You know what we do in Nigeria?
Yeah.
For us that think we have money, since they are all stand is that it's a teaching hospital and they want no content, I just leave and go to private hospital. That's what happens.
Yes, I thought it was the last. Okay. Just one more, and that's it.
Doctor, I think there are exceptions to that. I teach in the university, and the closest to the hospital to me is my teaching hospital. I will not walk into a consulting room with my students in it, and they will tell me that because it's a teaching hospital, they have to observe. There are consents, and it is allowed. Teaching hospital or no teaching hospital, it is allowed. And when environmental religion comes in, I've seen situations where a male doctor will never touch a Muslim woman, even if it's the only doctor in the hospital. So there are exceptions.
Okay, so I think we're going to continue this over dinner. That's dinner now, right? Okay, so we're going to continue this over dinner. It's a very lively conversation. Keep it alive during dinner, right? Good. Thank you very much.
Patient-centered